Buju ni dinaway magani dog, niji nishnabeg niji pamadazig. Bangie tagon ninata nishnabem, ingaguji tunji nishmayan. Giganos ndijnakas, nea shiwa nigaming and donjaba, nigigan dodam. Anui dijndan chanakanagewan nungum. I'm really grateful for the opportunity that I have to be able to speak with you about Indigenous legal traditions today. This is something that's really close to my heart. I grew up on a reserve that's about 4 hours north of Toronto in Ontario, about 5 hours north of Detroit. It's on a place called the Bruce Peninsula. On the one side is the Georgian Bay and the other side is Lake Huron. And as I speak today, there'll be pictures of this reserve and of my family that will be scrolling through this presentation. The reason for this is I want you to see, first of all, the beauty of the place and invite you to come and visit us there. There's so much that you learn about Indigenous law when you're actually gathered with the people. Indigenous law is living, and it's not just an idea on a piece of paper. It's drawn from relationships. And as you understand the relationships of people, as you understand the relationship of people to land, you understand more about Indigenous law. And so these places with the rocks and the waters and the escarpments and the winds and the waves are something that nourish Indigenous law, something that nourish Ojibwe law. That's the nation that I'm from. We're also sometimes called Chippewa or Ojibwe. And we're a pretty big nation. There's about 100,000 of us that live in Ontario and Manitoba, Minnesota, Michigan, and Wisconsin. And we surround most of the western parts of the Great Lakes. And as a result of this, we take from one another our understandings about how to live well in the world. When we talk about law in Anishinaabe terms, the word we use is Minobamadazuin, which is living well in the world. The idea is to look at patterns of behavior and find good ways to be able to persuade one another as to how to replicate good patterns of behavior. Our actual literal word for law is Chi-Anakinogewan, which means the great guided way of making decisions. And that's important to us to be able to understand that it's something about decision making. Law is not just given, once upon a time handed down from on high. It's something that's active, that's a part of the way we work with one another today. So Chi-Anakinogewan, I'll be speaking about this sense of law which flows from the rocks, the waves, the rivers, trees, etc. Now, one of the things that we could do if we were home on this reserve is I would take you out to these rocks and you would see that all along the shore are these very flat limestones. And it's very interesting because every once in a while you get surprised as you turn over a limestone, you'd see a fossil. Because you recognize that what you're seeing there is a land that has rocks from 440 million years ago. This is a time when Ontario was like the Great Barrier Reef. It was at the equator, and it was a tropical sea. And so the escarpments and the fossils that are part of this water communicate an older sense of place. They let us know that even as Ojibwe people, we are newcomers here. And that gives a sense of humility in the world. As you learn about the law, you recognize that you're not the center of the jurisprudential universe. Just as the common law and the civil law is not all things to all people, so it is with Indigenous law. It's one of the many systems that we have in Canada, and yet it does have great wisdom. So if we were along the shore, I would take you, we would explore the fossils, we would look up to the escarpment, but I'd have you take them in your hands, and I would have you take a small one and see how many times you could skip it across the water, how many bounces you might be able to get. The point of that is that my lecture today is going to be a little bit about skipping stones. We're going to go over a lot of information in a very short time, and eventually the stone will drop, and it's going to take you the rest of your time in working with Indigenous law to try to understand that more clearly. And so, with this sense of using Indigenous law in this way, I want to start out by talking about the sources that we have as Indigenous peoples of law. I've already mentioned one of these sources, which is the environment. As we draw law from the environment, we find analogies there about how to be able to behave. We also find things that we can distinguish from our behavior. Our word in Anishinaabe for learning law in this way is called Akinomagewin. Aki is the word for earth. Nomage is to point towards the earth and take direction from it. So a kinomagewin is the sense of learning from this place. I'm going to tell you a story that comes from our creation, which is this millions and millions of years ago when the world was just all covered with water. And there was a being that fell through the sky, our trickster, Nana Bojo. And as he was falling through the sky, he was looking for a place to land, and he didn't see anything that would give firm ground to him. So he called out for help. Widu Kawishin, help me. And as he was falling, a goose came along and caught him on its back. And he was there on the goose's back for some time, and they flew over the earth looking for a place to be able to find firm ground. And they flew for days and days, and there was nothing. Eventually, he called out again, Widu Kawishin. He asked for help. And in asking for help, this giant turtle emerged out of the water and gave its back for Nana Bojo to be able to gather there, the trickster figure, Nana Bojo. So on the turtle's back, Nana Bojo floated, waited. They swam looking for something firm. And it was some time and they were not able to find it. Eventually, Nana Bojo called a council of the animals. Widu Kawishin, please help. An interesting principle of law. Looking to others when you try to find out what you might do in the world today. So he called on this council of animals and he asked if anyone had seen any earth anywhere. And the answer was no, Gawin. And they thought about and they talked about what they might be able to do to find the gift of the earth. Eventually, the great diving animals volunteered and said, well, maybe there's something below us. Maybe we'll be able to find it there. And so first of all, the beaver dove down deep and spent a long time in the water and came up, said there's nothing there. There's nothing firm beneath what we're seeing here. Well, the otter wasn't quite convinced. The otter thought he was a more powerful diver. That's my clan, by the way, Nagigan Dodem, the otter totem. So the otter dove down. And in diving down, again, spent a long time, but again came back to the surface and was not able to find anything. So then another diver went down, Mong, the loon, for a long, long time searching for the earth, came up with the same result. At this point, the council was getting discouraged. Suddenly, a little one spoke up, the muskrat, and said, I can do it. I can get that earth. And all the other animals tried to dissuade him, saying, how can you possibly think you're going to do that when the beaver and the otter and the loon didn't succeed? They were just not giving him any credit. So Nana Bojo spoke up and said, let's listen. Let's listen to this little one. Sometimes the case that we think we know what's better when it's those that are smallest amongst us that might be able to have a sense of what can be accomplished. So down that muskrat dove and was gone for some time, longer than the beaver, longer than the otter, longer than the loon. Eventually, the council forgot about him. They went on to other things, but through time they noticed up popped the water, this little object. They scanned the horizon, they saw that it was muskrat, so they swam over. There was no life. Muskrat seemed to have perished. They tried to revive the muskrat, but there was nothing they were able to do. Nana Bojo, who's known as the great hare, the giant rabbit on this turtle's back, mourned. The rest of the council mourned. And they wondered what they could do to honor this one, because he gave his life trying to bring up something for other people. Think about all the principles of law that I'm talking about as this case unfolds. Right? What are the criteria or the standards for judgment that are found here? What is the measures that you see about how we should behave based on what this council did in trying to bring about this gift? Well, they mourned, and in mourning they decided they were going to honor him, the great rabbit, Nana Bojo. They laid him out with his feet facing towards the west so he could walk across that Milky Way, what we call the Chibai Mikana, the land or the path of souls leading to the land of the dead. And as they laid him out, they wanted him to look natural. And so what they did is they started to put his limbs in a more natural position. Then they started to open up his little paws, and they found sand. the little muskrat had actually succeeded in getting below the water and bringing up this soil from the depths. And they were thrilled. And what they started to do as they looked across the stars and as they looked across creation, they started to sing and to dance. And they danced on that turtle's back in thankfulness for what the muskrat did. And they put that soil in the four directions that he had in his claws on the turtle's back. And as they started to dance on the turtle's back, a miraculous thing happened. Because as they ground that soil into the back of the turtle, where there was all that organic matter, there was a generation. Things started to spontaneously grow from them. They would grow and they would decay and they would grow and they would decay until the turtle's back became covered with soil. And as they continued to dance, the earth continued to grow. And as they celebrated on that back, they were able to remember what that little one did, and they also remembered the importance of recognizing that creation is ongoing. That the process of lawmaking is not something that was just once upon a time in a frozen moment brought up from the earth. It's something that we can continue to cultivate, to inculcate, to find ways to be able to watch it grow and it decays, and it grows and it decays. Well, as this went on, we eventually come to have what we know as Turtle Island, which is what the Anishinaabe people call North America. And this place, from this kind of story, illustrates one of the sources that Indigenous peoples have for actually many sources. In this story, you see sacred law as being one of the sources of Indigenous law. People look to their origin stories and they try to figure out from those stories what messages were passed by our ancestors about how we might live today. Now there's other origin stories in the law. Spent the last 5 years or so teaching at the University of Minnesota Law School, teaching U.S. constitutional law. They have a great sacred origin story there. It starts in the 1780s. And they have what they call the founders of the nation. And they look to these founders and their origin story to try to be able to figure out how they can produce their law today. What happened when the United States of America was formed in their creation becomes the touchstone for judgment and how constitutionalism is practiced today. Likewise, within many Indigenous traditions, we look to those original stories as constitutional, to try to figure out what we might have today. Now, we don't have the founding fathers, like was the case in the American context, but we have the founding council, right, of the animals and Nanabojo and what occurred there. There are other kinds of origin stories that we look to in Canada. The treaties are a kind of an origin story. Because they talk about how Canada was formed as Indigenous peoples gave permission in many parts of this country for settlers to be able to live on the land. It's often said that treaties are a grant of rights from the Indians, not to the Indians. The First Nations granted rights to settlers to be able to live in this place and share in this legal order that they had been stewarding for many thousands and thousands of years. So that's one of the sources of law that you'll find in Indigenous communities, and you'll find, of course, different stories in many places. When you go through the Vancouver airport, right, you'll see the Haida canoe and that journey through time. Maybe you've seen the raven opening the shell with the people coming out. Another sense of constitutionalism is embedded there. Because as you listen to that series of stories, you learn what their principles for judgment are. But another thing that I've been talking about here is also nature, looking to the behavior of plants and animals and the way that they interact in the world. There's a picture of a strawberry right here. In our language, this is ode and min. Our word for heart is ode. Min is berry. The strawberry is a heart berry. One, because it's shaped like a heart. But two, the roots, when you boil them, actually are very medicinal. And they help to cure certain set of diseases. And when people look at the plants and they recognize the healing properties that can come into our world, they told stories about that. And they made these plants animate. And so Odeamin is also a little boy who, when he was young, his parents passed away, and he was left all alone in the world and grieved that loss. And he wanted to meet his parents again. And so he traveled to the land of the dead to try to get them to understand what he could do. And on that journey, there were many principles that he learned about how to live well in the world so that when he came back, he could help people. This idea of learning from the land, I've already mentioned the word akinoma is reasoning by way of analogy, right? It's looking to what's there in nature and trying to pattern your life or distinguish your life from what you see in nature. What's important in this is to recognize that sacred law and environmental law is never self-reinforcing. It requires a human community to be able to pick it up and to talk about it. And that needs a very active process. It's just like the common law and the civil law. It doesn't just happen that people live in accordance with it. Each generation needs to put their efforts into revitalizing it, to making sure that it grows today. It's been said that tradition can be the dead faith of living people or the living faith of dead people. And one of our challenges as practitioners of law is to make sure that our traditions are the living faith of us today, the living faith of those that have come before who are now dead, not something that is dead in us who is living today. And if traditions are living, what that means is that they need to take account of not just what happened in the past, but also what's happening today and what we might think happens in the future. In other words, in order to be persuasive with one another, we need to think about all parts of our world and what will be helpful to people, what might cause them to develop a sense of being in the world that would implement these principles. I have here a belt that the Anishinaabe people entered into with their enemies for 100 or so years, the Haudenosaunee. The Haudenosaunee are the Six Nations people of the eastern Great Lakes: Mohawk, Oneida, Seneca, Tuscarora, Cayuga, and Onondaga. And they lived south of the lakes, we lived in the north of the lakes, and we kept warring with one another. And those wars brought great hardship, and obviously were not not a good way to be able to lead a life. And so what they did is they entered into a treaty. They entered into an agreement to be able to resolve their conflicts with one another. They engaged in deliberation, they engaged in persuasion. And this treaty, rather than being set out on a piece of paper, was woven into a belt here. And this is strings of hide and sinew to which little shells are affixed. And you can see in putting this together that there's a pattern that's a part of it. And what they wanted to talk with one another about is having peace. And peace is the color white. And so this is the way the people decided that they would mark what their agreement is, being peaceful with one another. There's also 7 rows of white. Each one of these rows has a meaning about how the people would put their lives together. So they would live with love and kindness and respect and bravery and honesty and courage and truth. These are what's called the 7 grandmother, 7 grandfather teachings amongst the Anishinaabe. And they're somewhat equivalent to what you would find in the Charter of Rights and Freedoms when people talk about equality and liberty and security and association, right? They're broad general terms. They're aspirations as to how people should live, like equality. It's a very general level. And then the work of putting equality together is then done in particular contexts. And so it is with truth or love or respect or bravery or friendship. So peace and the 7 grandfather and grandmother teachings are a part of this belt. And then in the middle there, you see a purple almost circular-like dish is what it represents, which means that the people were sharing from the same territory as they were coming into conflict from both sides. And so the sense is that when we live on the earth, we eat from the same dish. And we need to make sure that we do not put things into that dish or take away from that dish in a way which would harm others. And in the middle of that dish is this little white object. It's a spoon. The reason for a spoon is that there's no sharp edges with that. So that when you're sharing together, you're not coming in with threatening gestures towards others. And so this treaty, which was which was put together in the 1750s, actually 1650s, is still valid amongst us today as Haudenosaunee and Anishinaabe people. It shows this other source of law, deliberation. Now, when we encountered non-Indigenous peoples in our territory, we produced another kind of a treaty. Notice that when we produced this treaty with first the Dutch, and then the English, and later the French, we drew upon Indigenous forms. They might have written this down in writing at some point, but this is what they presented to us in council. Now, what does this mean? This is a belt which is called the Two Row Wampum Belt. Again, you see white as the dominant motif here. That means that Europeans were to live together with Indigenous peoples in peace, in friendship, and in respect. And then this motif is repeated again. Peace, friendship, and respect, because there's three: peace, friendship, and respect, three white again, peace, friendship, and respect. In other words, putting our lives together in legal terms in North America was to be done with this value at the heart of it. We were to be mingled with one another. But then there's another motif on here, which is these two purple rows. Something my great-great-grandfather is being shown on the screen here. His father, it was just shown before, entered into a treaty dealing with 1.5 million acres of land in southern Ontario, going from Goderich to Arthur up to Collingwood and then north up the Bruce Peninsula. When he signed that treaty by marking his little otter totem, his little clan marking there, he signed a treaty with this in mind. In other words, you can't just read the treaty that deals with the 1.5 million acres of our traditional territory by that little document alone. You have to read that treaty which took place in 1854 against this treaty which took place in 1764. In other words, the treaty relationship is a cumulative relationship. And part of what they agreed to was that they would live in peace and friendship and respect, but then we also have the river of life that we both traveled down. And the First Nations people in their canoe traveled down their river of life. This is my grandfather in the boat where he taught me how to fish. I spent many hours on this bay learning the stories about what it means to go down this river of life as an Anishinaabe person and try to take to heart and live the laws that he was teaching. And then there's this other river here, this other purple row, which represents the Crown, Great Britain, going down its river of life in its ship of state, controlling its own affairs. Notice the parallel nature of the lines here. This is why we sometimes say that we have a nation-to-nation relationship with the Crown, because there was a recognition that we would share, and there was also a recognition that our autonomy would be protected. So that when I came into the world, and this is my mother holding me as a young boy, part of what my responsibility was is to take these white rows and find ways to knit ourselves together in peace with friendly ways, but also to find those possibilities that enable us to develop our own ways of steering our craft. And so this belt in 1764 was shared by the British with us, and there were 24 different First Nations that were gathered in that period This is an amazing gathering. It took place at Niagara. This is one of the first things that took place in Canada after the 7 Years' War, when Britain was trying to claim rights to be able to live in this country. Right? They fought against the French. They defeated the French on the Plains of Abraham. The Indians, Anishinaabe and others, were allied with the French at that time. But when they defeated the French, they didn't defeat us. We were the allies of the French. In fact, we kept fighting the British. So they beat the French, but what immediately happened to them, the British, is they lost all the forts that were from down in Pittsburgh over to Detroit, up to Michilimackinac. In losing those forts, the British recognized they couldn't just do what they wanted in North America. So they could continue on with war against us, or they could enter into an agreement of peace. They chose the path of peace. And so in 1764, for 2 months, one of the first things that we did to found Canada was build our relationship on deliberation, on persuasion. It wasn't about forcing Indigenous peoples or the Crown to be able to live in a certain way, another way of recording law. It's trying to find ways that we can knit our lives together by talking with one another. This is our great 250-year-old treaty tradition that went all the way across Canada and then stopped at the Rocky Mountains. Although there are a few treaties here, the Douglas treaties on the southern parts of Vancouver Island. There's another treaty, Douglas Treaty in the Nanaimo, and then one on the north part of the island. But this is to make the point that one of our sources of law that is Canadian law as well is built on deliberation, built on persuasion, built on trying to live together in the present context. And notice that it's built on Indigenous forms. So when you read a treaty, you can't just read it in isolation and just interpret it by common law doctrines. You have to also interpret it by Indigenous legal doctrines, because the two legal systems flow together. The Supreme Court has said that this area of law is intersocietal. They use a Latin word, they call it sui generis, meaning unique or of its own kind, meaning that it's not just drawn from Europe, neither is it just drawn from here. There's an intermingling that happens. The law dealing with Aboriginal peoples in Canada, in terms of constitutions, is a bridge between the legal systems. The Supreme Court, in a case called Vanderpeet, said a morally and politically defensible conception of Aboriginal rights will incorporate both legal perspectives. So Indigenous law is not only the law of Indigenous peoples, it's also the law of Canada. In fact, it is the law that founded Canada. And I sometimes wonder why we don't celebrate this more. Why wasn't there big celebrations in 2014 about the Treaty at Niagara? 250 years of peace, setting a way to live in the world that doesn't use the sword or the other weapons, right? It tries to knit another way of being. So that's a source of law. We have other sources of law that the courts recognize that flow through custom, established ways of doing things through the generations together. So what often happened in these early periods is that people would travel up from Europe or travel up from Quebec, and they would intermingle with Indigenous peoples across the country. Often this was men circulating out, forming relationships with women, and these relationships were often solemnized in accordance with Indigenous legal traditions. And the men were happy to abide by them. The women and the communities were also, by and large, happy to abide by them. And you had, not only in public law, Indigenous law being a part of Canada, you also had in so-called private law, right, laws that are formed more just between individuals as opposed to nation, being this intersocietal, many streams flowing together. Now, there was an interesting case that came to the Quebec courts in 1867, the first year of Confederation. It's called Conley and Woolrich. There was this trader that went out from Montreal and spent about 30 years living amongst the Cree and Métis people. And in this life pattern, he married a Cree woman in accordance with Cree custom. And they had, by all accounts, a good relationship, and they had 6 children. Eventually, these 6 children, some stayed on the prairies, some moved back to Quebec. He eventually moved back to Quebec, and his former partner was left on the prairies. He then took up with his well-to-do second cousin and got married in the Catholic Church. And then he died. And there was a question about his estate. To who would the goods that he had accumulated go in administering his estate? Now, the second marriage, there was a claim, well, they should go to that marriage because that's a valid message. That's a valid law that was formed under the civil law of Quebec and was solemnized in the Catholic Church. And so the people of that union would be the ones that would get the benefit of the estate. The court was told by the lawyers for this second marriage that the law is not half civilized and half savage. Right? The law cannot recognize Indigenous legal customs. It can only recognize what happened in accordance with these Christian and civil law traditions in Quebec. So the court was asked to consider whether or not the estate would go to this second marriage or whether or not the goods would go to the first marriage. And the court came to the conclusion that it would go to the first marriage, because that marriage, although done in accordance with Cree custom, was the law of the country. And here's what the court said. Justice Monk, who wrote the decision, poses a question. He says, first of all, will it be contended that the territorial rights, political organization, or laws and usages of the Indian tribes are abrogated? That they ceased to exist when these 2 European nations began to trade with the Aboriginal occupants? Right? So he's saying, did these laws suddenly go away just because Europeans came amongst them? That was his question. Did they go away? And he answers his question. In my opinion, it is beyond controversy that they did not go away. They were not extinguished by the British and the French, and that so far from being abolished, they were left in full force and were not even modified in the slightest degree. So here, in the first year of Confederation, there's a recognition that Cree law, which solemnized a marriage, can be given force in the courts of the civil law in Quebec. This idea that law is pluralistic, that it has many sources, and that we can draw on those sources in putting our laws together today is something that Indigenous people see in their own ways of proceeding, and that they've also invited others into, and now is a part of Canadian law more generally. And when you learn more about Section 35 of the Constitution Act and our broader jurisprudence, you'll see this framework embedded in our law. And what our opportunity is today is now to try to find ways to revitalize that and to make it stronger, and to work in this generation to persuade one another, to deliberate with one another what it's going to take to make that so. Another source of law also comes from positivistic declarations. This is the old house of the Indian agent that lived on our reserve. The Indian agent had the last word in so much that was taking place in accordance with the way we were administering our authorities in our band. If we passed something in council, it wasn't law until the Indian agent said it was law. It's a terrible system of oversight, very paternalistic, trying to control our ways of continuing our law in the present day. Fortunately, in 1969, and in most places across the country, the Indian agent was kicked out. And so now when First Nations try to promulgate law, they still have the Indian Act, which constrains much of what they can do in trying to exercise their broader legal traditions. But nevertheless, when they exercise authority, even in that constraint, they do so through positive proclamation. They pass bylaws. And those bylaws are like regulations that when you're on the reserve, you have to abide by. And if you don't, you'll find yourself cut out or not being able to participate in many of the possibilities that are there. We didn't just have positivistic law that flowed from the Indian Act bans, though, hereditary chiefs, traditional leaders, clan mothers, others would make proclamations about what you should do in certain times and in certain places. So there's many kinds of law that we have. One of the things I want to do just as we go through this last point now is give you an example of how this is all pulled together in one case. This is a case that comes out of Ontario, again, from the French River area in 1838. The French River is just south of Sudbury, north of Muskoka, on Georgian Bay. And there was a man who was traveling with the Anishinaabe at this time. His name was William Jarvis. If you've ever been to Toronto, there's a Jarvis Street. This Jarvis Street is named after William Jarvis because he was the Indian agent for the government of Upper Canada at this time. And he observed Anishinaabe people practicing law. He observed the kinds of ways that they would deliberate with one another in trying to come to answering the questions that they had. And this particular case deals with, well, I'll just let it speak for himself. He writes as follows. He came among us at the very beginning of last winter, having in most severe weather walked 6 days without either kindling a fire or eating any food. So the case begins with this man coming amongst the Anishinaabe at the beginning of the winter. During the most part of the winter, he was quiet enough. But as the sugar season approached, he got noisy and restless. The sugar season is when the snow begins to melt and the sap runs through the trees. So perhaps late March, early May. So from the beginning of winter to the sugar season. Then he became noisy and restless. He went off to a lodge and there remained 10 days, frequently eating a whole deer at 2 meals. After that, he went off to another lodge. When a great change became visible in his person, his form seemed to have dilated, and his face was the color of death. At this lodge, he first exhibited the most decided professions of madness, and we all considered that he had become a Windigo, a giant. He did not sleep, but kept on walking around the lodge saying, "I shall soon have a fine feast." And soon this caused plenty of fears in the lodge, among both the old and the growing. He then tore open the veins at his wrist with his teeth and began drinking his blood. The next night was the same. He went out from the lodge and without an axe broke off many saplings about 9 inches in circumference. He never slept, but worked all that night, and in the morning brought in all the poles he had broken off, and at 2 trips filled a large sugar camp. So think about what's happening here, right? Here's a remote community, end of winter. As they're together, there's a threat. Not only a threat to this person himself, as he's obviously self-mutilating, obviously is very troubled with a mental and psychological challenge, but the threat is also something that the entire community is facing. It's the reason that he came amongst them at the very beginning of the season so that people could watch and see what they could do to help this person out. But as he's with them, things start to grow worse. So what would you do if you were in 1830 in a remote bush in Ontario? Well, the Anishinaabe people had resources to do something about it. They had their own systems of law. And so here's what they did. The Indians then all became alarmed, and we all started off to join our friends. Interesting legal principle. The snow was deep and soft, and we sank deeply into it with our snowshoes. But he, without shoes or stockings, barely left the indent of his toes on the surface. So this must have been a pretty tough journey. To walk through these woods at that season to get to their friends, right? And they're all sinking through except the Windigo, who's obviously so emaciated He's light and not sinking in. This is the month in Anishinaabemowin that we call Bokadekwe Gizis, the snowshoe breaking moon. They didn't lightly go off to visit their friends, because when the snow in May and April is hard on the crust, the hard crust on the snow moon is how you'd call it in English, that can be a treacherous time. But they obviously felt it was important to follow these procedures. This person they were taking with them was stark naked, tearing off all his clothes given to him as fast as they could be put on. He still continued drinking his blood and refused all food, eating nothing but ice or snow. So what did they do? We then formed a council to determine how we should act, for we feared he would eat our children. Right, so this is something they've done collectively, because they watched him over an entire season, and then they went off to join their friends, and now they form a council to decide, right? Not one person is given the responsibility to say, here's what you need to do. It's this process of deliberation, again, that flows from watchfulness. So here's what they did. It was unanimously decided that he must die. His most intimate friend undertook to shoot him. My heart breaks with that. Not wishing any other hand to do that. And then here's a part I don't understand. After his death, we burned the body, and all was consumed but the chest, which we examined and found to contain an immense lump of ice, which completely filled the cavity. That doesn't correlate with the way we understand science today. If someone is emaciated, has been through a cold season, but you can read hundreds of these Windigo stories, and most of these cases talk about when they perform an autopsy that this person has a lump of ice in them. There's something here that's metaphorical that's going on in trying to describe what was going on with this person and why they needed to take the action that they did. Now, goes further, the lad who carried into effect the determination of the council has given himself to the father of him who is no more, to hunt for him, to plant for him, and to fill all the duties of a son. Think about that. This wasn't an act of anger or malice, right? His most intimate friend took the life of the person, and then that person became the son to the man that had lost his son. Imagine in Canadian context, if whenever a judge sent someone to prison, that judge then had to take the role of that son, that person that's been lost. There's a restorative element here in this, even as you see something that's harsh, right? The taking of life. You can't just think that all Indigenous law is about harmony and restoration. A part of it is, but a part of it is also trying to make sure that there's the appropriate actions that are taken at other times. Then the affidavit of Jarvis ends by saying, "This deed was not done under the influence of whiskey." There was none of it there. It was the deliberate act of this tribe in council. So if we think about this case, we find resources for reasoning in the present day. We find precedent here, right? We find criteria for judgment. We find principles. We find standards for authority. We can measure what we do if we analogize some of what they did into our life. Now, we're not going to take anyone's life today, right? So there's some things we're going to distinguish because we know more about mental illness in the present day. And we would perhaps use this process to get this person the help that they needed from contemporary medicine people within the communities and from the contemporary health system. And we would try to bring aid to that person in this way. But the principles would still all apply. We just wouldn't have that outcome be the same kind of outcome. This method is very consistent with what happens in the common law as well. We don't always focus on what the outcome for the decision was. You focus on what the process was that they used to arrive there, And you also focus on then what the principles are that they used in reasoning towards that process. What's so significant about this for me is I understand that there's a much broader legal system that is present in here. You find legal steps for dealing with Windigos, recognizing warning signs, right? The person arriving alone, the way they appear, they're hiding. You observe, you gather evidence to determine whether or not someone fits that category of Windigo. You determine what the best response would be. And death was often not the response. Maybe in 100 cases, you would have 2 cases where people needed to be put to death. You have a whole spectrum before that where people could be treated with kindness and caring and questioning and healing. And if that doesn't take root, then you might have separation. If that doesn't take root, then you might have some supervision. And if that doesn't take root, maybe banishment. And as the last resort, death. Right? So there's principles, there's steps that you can see here that aren't just dichotomous. You can see sophistication, gradation in trying to pull ideas together. You also find that there's responsibilities towards the Windigo as well as you look at these stories. And I'm quoting from Hadley Friedland, who's doing her PhD at the University of Alberta in drawing out some of these principles as well. She said there's a responsibility to help and protect towards the Windigo, which is also a responsibility to warn people in the community too. If there's someone that's going to be harming them, you don't just keep that quiet, or you make that a part appropriate with due process, still an appropriate part. There's a right that this person who's a Windigo has a right to be heard, to be able to present their side of the case. There is a right of decision. Here's the closest family members that are part of the decision. The Windigo, the person who's accused of or is damaging to others, has a right to life and liberty and security. And you can see in this story, they spent a long time, and we just got a snapshot, they spent a long time trying to do all they could to help this one until it was just apparent he was going to either take someone's life or take his own life. He has a right to be helped, as I mentioned, also a right to ongoing support. Val Napoleon writes Mikamosis graphic novel, which picks up many of these principles and introduces the important element of gender, which we always need to consider when we're working with Indigenous law. We need to be careful not to replicate stereotypes and generalizations around gender. We need to recognize that people have many different gifts and they don't just pick up one role or one way of being in the world. And so it is with gender. And this Mikamosis treatment that Val has developed shows how gender needs to be brought as a critical lens to understanding Indigenous law. And it's not just questions of gender, although it is questions of gender. We also need to take our wisdom that we learn in law school and other places and ask about administrative law principles, natural justice and fairness, etc. We also need to ask about other things that we pick up as we go along in our responsibilities. So, we've been together about 50 minutes, and we spent our time thinking about the different sources of Indigenous law. We talked about them being rooted in the environment, that there's sacred elements that can be drawn out from this. We also learned that some of this law comes from deliberation, and other pieces are generated by custom, as the Conley and Woolrich story talked about. Some of those laws themselves are positivistic. So there's different sources of law that Indigenous peoples have, which shows you that Indigenous peoples have choice when they practice law. They don't just have to be automatic and lockstep, right? This is a human endeavor, a creative exercise that involves working together in council, in deliberation with one another. And it's not just that Indigenous peoples will deliberate with Indigenous peoples. We invite other peoples, law students, others, to be a part of this conversation, to be able to find ways to revitalize these traditions, because as that Windigo story shows, friendship, as this belt shows, friendship is an important part, an important dimension of developing law. As we see law in that light, we see that law is not just an idea. Right? Law really is, at the end of the day, a practice. And if it's a practice, it's not just for you who are going to law school and going to be specialized as lawyers. You can be a part of that practice, but we need to figure out how we draw other people into that practice. And we help to revitalize these traditions to make Canadian law much stronger in accordance with our 250-year-old traditions, and then in particular legal traditions to find how to make Anishinaabe, Blackfoot, Cree, Haudenosaunee, Haida, all these other people's laws as strong as they might be in contemporary terms, without generalization, without stereotype, working in the subtleties and the sophisticated intricacies of how that system should be practiced. So, as we began, we were in the territory, and I took you to the shore, and I showed you the rocks on the beach, that we'd pick up a few of these stones and skip them across the water. That's all we've done in this little time that we've had together. Just skip over the surface of some of these things that Indigenous peoples have as law. Know that there's great depth below that surface. And my invitation to you is to be here with us as that stone drops. And also recognize it's not just a horizontal activity, there's also something vertical there. The depth of Indigenous law is something that's real, and I'm grateful to have that as a part of my life. Miigech bizinduwe bi'u ahau. Thank you.